Just wait for 5 seconds, Sahil. Okay, you're live.
So warm welcome and thank you for joining for this amazing session on IP. Based on the responses we received from our interaction with students like you, we have noticed that there's a big gap of knowledge on knowing your rights for the idea or project you have been working for. Most of the audience we have today are registered students from various parts of India. My message for you is now that you have registered, the deadline to submit your innovative idea is by 30th. To the new ones, I would like to introduce you to our flagship innovation platform, that is KPIT Sparkle, a platform that connects budding entrepreneurs and innovators to incubation ecosystem to bring innovative products to the common man. Today's IP session would be conducted by the KPIT's IP team experts, Pranjali and Pallavi, who are engineers and registered patent agents. They have significant years of experience in the patent domain and join with me to welcome them. Over to you, Pranjali and Pallavi.
Thank you, Sahil. Thank you, Sahil, for the introduction. We will now begin with our session. We will be putting this on the slide mode, please. Yeah. So, like Sahil has mentioned, this session is being conducted under the KPIT Sparkle initiative, and today we are going to talk about intellectual property rights. So, we are going to look at some basics of intellectual property rights. We are going to look at some detail about patents. We are going to look at some of the patenting processes, and we would be concluding with some highlights and some FAQs. So moving on, let us begin with the session now. First of all, we will address what is intellectual property rights. So we hear this term IPR. So basically, intellectual property rights. If you see intellectual property, what does this mean? So intellectual property is any innovative or unique solution or creative solution that comes out of your mind or your intellect. So basically it is an idea or an invention or an innovation that you have thought of, that you have come up with. This idea could be in the form of a product, solution, method, process, system, or anything. So any creative, unique, and novel idea that has come out of your intellect that you have thought of is termed under the term intellectual property, and the rights that are conferred for this intellectual property that you have created are exclusive rights for manufacture, sale, license, export, and generating any kind of revenue out of that idea are the rights. So this is what we mean by intellectual property rights. So an idea that you have originally come up with, that you have thought of, and you would get some exclusive monopoly rights for that idea. This is what is the basis of intellectual property rights. So moving on, we will look at what is the importance of IPR. Why is it so important? So IP basically defines the innovation quotient or index for various entities. So let's say you are a student, so or a company or an institute or a college or an organization or maybe even country. And if somebody wants to know how creative you are or how innovative you are, then IP portfolio will definitely give you a very good gauge of the innovation quotient for any entity. IP assets are basically a dipstick for the entity valuation as well. So let's say if it's a company, then the IP portfolio will be an important asset which will be valued during any kind of commercial transactions that would be happening, like mergers and acquisitions, or if there are any investors that are looking at a company. Also, the innovation part of any company is a very important differentiating factor for that company in the market. So whenever customers are looking for service providers, they will look at how innovative a company is or how innovative their products or solutions are. So even for you as an individual, if you are a student or if you are having a startup or are planning to start with a new kind of incubation for your idea or anything, the innovation quotient of your solution or service or product, whatever you are bringing out to the market, will be defined by your IP portfolio. That is what kind of intellectual property you have and what is the size of your portfolio. Apart from that, needless to say, IP rights also give you a lot of economic and monetary benefits in terms of commercialization and revenue generation. They can be also used, your IP portfolio can be used as a various forms of financial instrument. In various ways, it could be used as a financial instruments, like they could be used as a collateral. Another important aspect of the importance of IPR is, why we need to know is, any kind of improper handling or improper use of IP can also be a big risk factor for an individual or a company, leading to significant business, legal, or financial consequences. Hence, there has to be a certain level of IP awareness, and you need to know about certain basic aspects of IP so that you can take care of these things and avoid any kind of IP risks. Moving on, now we will see why we need to know about IPR in detail, especially since this is under the KPIT Sparkle initiative and we have students who are participating in this innovation contest from across the globe. So as students, you would be submitting your innovative ideas in this contest. Since they are innovative ideas, it is all the more important that you have to understand that if your idea is really novel and unique, then you have the right to file a IP for that particular idea so that you get a monopoly right for that idea. Not just for students, for employees, companies, and entrepreneurs, everyone who are working on developing any kind of unique solutions, IP plays a very significant part. So you need to understand this whole aspect of innovation, where you are able to identify, you have the capability to identify that you have a unique or a novel idea. You need to have that awareness that you can get exclusive monopoly rights for commercializing that idea, and you also need to have some basic understanding of what is the process of getting those IP rights, or registering for those IP rights. So for all these reasons, it is important for you to know about IPR. And just like you would be protecting your idea, somebody else also will be protecting their own idea. So the other aspect of IP is, while you protect your IP idea, you also have to be aware that you are not infringing or not misusing or improper use of anybody else's IP. So that also is an important aspect of IPR. We will look at this briefly in one of our further slides. So for these various reasons, it is very important that you be an IP aware person. Moving on, we will talk quickly about some of the terms that are frequently used related to innovation. We always talk about, idea, invention, and innovation. We say it's a great idea, it's a great innovation, but what do each of these terms really mean? So when we say about an idea, it will basically give you the what part of the idea. So it is a conceptual part. Invention is when you are able to actually implement that idea, or you have the how-to part of it, or you know how to make that idea feasible, then it becomes an invention. And when you are able to bring that idea out into the market in the form of a product or a solution, and you're able to commercialize it, then it becomes an innovation. So the idea life cycle begins with an idea where you have a conceptual definition for your idea, then you work on it and make it feasible and convert it into an invention, and then you take it to the market and then commercialize that idea. These are the basic stages of an innovation life cycle. So to give you a very simple example to understand these concepts better, a very simple example would be, let's say I have an idea that I want a car that changes color every day. Now this is a very great idea, but that is what it is. Unless and until I know how to implement it or how to make it feasible, I am not I am not going to be able to make it feasible until I know how to do this. So once I have the procedure of how to implement it, then it becomes an invention. And when I actually bring it to the market and commercialize it, then it becomes an innovation. So you as a student, or as anyone who is into research or developing new products or ideas, work and having interested in innovation, you have to remember that you have to take your idea throughout this life cycle, and you have to put in efforts in each of these stages to take your idea to the next stage. Moving on, we will now look at intellectual property rights, basics of what are the various types of intellectual property rights. So basically they are categorized into two buckets, which is the industrial rights and the copyright. So under industrial rights we have some other subtypes. We will look at those now. Patents, we will talk about them in detail in our further slides. Another type of industrial right is the trademark. So trademark is basically given to identify and distinguish a particular service from the other services in the market. So a trademark could be a word, a logo, or a symbol, or a combination of any of these and any such other similar features. So to give you a simple example, KPIT, we have this logo, which is a trademark of KPIT. So any product, solutions, offerings, or services that KPIT gives out to its customers or in the market will be having this logo. So people would identify a particular service with a particular company. The next is the industrial design. So this kind of IP rights is given to specifically it is for the design aspect of any ideas. So it could be the shape or the size or the color or such things that are protected under the design. So the design or the aesthetic features of any product. So like the shape of the car or the shape of a bottle could be an example which is protected under the industrial designs. The next category of IP that we are going to look at is the geographical indicators or the GIs. So GIs are basically given to particular produces that are produced in a particular geographic locations. So because those products or produce are associated with a particular location, they have certain features or certain aspects which are local to that particular geography. So to give you an example of a GI would be Darjeeling tea. So now tea that is cultivated only in Darjeeling will have that particular, let's say, taste or fragrance, and only the tea that is cultivated in that particular region can be sold out as Darjeeling tea. So this is the example of GI. Moving on, another type of IP protection provided is the trade secret. Now, trade secret is a type of IP rights which is conferred for confidential information. So now this trade secret can be anything. It could be a formula, it could be a process, it could be some business related aspects, it could be a process, it could be anything that a company or an individual decides to keep it confidential and not disclose it anywhere outside in the public. Such type of confidential aspects or of the process or formulas or equations or any other such business related aspects are protected under the IP rights of trade secret. The last one in this category is the layout designs of ICs. So nowadays, with all kinds of electronic devices coming out too much in the market, with the appliances and consumer devices and so on, there are the number of IP chips in each of these devices and gadgets is increasing day by day exponentially. So the layout design of all of these ICs, which are unique and novel or different or providing some different functionalities, these are protected under the layout designs of IC protection. The other part of the IP rights is the copyright. So these are more for literary works like books, music, audio, sound, cinema, video, and all those things. So one primary distinguishing feature between these is industrial rights are for idea per se, or for the utility per se, whereas copyrights are more given for the expression of the idea. So let's say so on a single topic, on the same topic, two people will write a poem. So it is their expression of idea, and even if it is on the same topic covering the same features, it would still be protected separately. They both the poems would have a copyright protection because they are two different expressions of the idea. So moving on. Now that we have seen what are the different forms of IP protection, now there are so many products in the market. We'll see example of IP in various products. So every product or solution or offering given by the companies that is available in the market or to the consumer or to the customers will be protected under various forms of IP. So it's not at all necessary that one product will be protected only under one IP. So different aspects and different features of one particular product will be protected under different buckets of the IPs that we have seen just now. So just to give you an example and explain this further, if we take the example of a smartphone. So smartphone, let's say that the look and the feel and the shape and the design and the exterior of the smartphone may be protected under the design IP rights. Okay, the logo of the phone or the logo of the smartphone company might be protected under the trademark rights, whereas the apps or the functional features of the phone or the technicalities of the phone may be protected under the utility patents. And the IC, if there are any IC chips that are used in some any other devices, all the devices will be having the IP chips, so that will be protected under the IC designs IP rights. So one product will be can and should be protected under various forms of IP. Moving on, we will look now. We'll talk more about patents now in detail. So we'll see what is a patent. So like we have seen in the earlier slide, IP rights are basically exclusive rights that are given for your IP creation. So a patent, when you patent an idea, the government of each country will give you a exclusive privilege right that will be given only to the ideator or the applicant once you apply for a patent. And this right will be so that you are the only one who can sell, manufacture, license or export your patented invention. So you will have a monopoly right for your patented idea. Patents are territorial rights. Now, what does this mean? That if I file a patent for my idea in India, I will get exclusive monopoly rights in India only. If I want a monopoly right in US, let's say, or Europe, then I have to file a patent in US or Europe. So they are not, it's not like I will file in India and then I will get rights in some other country also. So they are territorial rights. A patent document. So now when you have a good, innovative and a unique idea, you have to file a patent application. What is this patent application? A patent application is a techno-legal document which will describe your invention in detail, and in detail that invention should be covering the specific solution to the problem statement that you are addressing. Now, in a patent application, there are different sections. Like we have, first we'll have the title, then we'll have the abstract, we'll have the summary, we'll have the drawings, we'll have the description, and we'll have the claim. So the description, in the description, you are supposed to describe in detail the solution or the how-to part of your specific problem statement that you are addressing, and you have to give in detail the description of how you are implementing that particular idea. In a patent document, the claims are the most important part of a patent document. So claims will basically define the boundary of your legal protection. So to explain this further, let's say your product has features A, B, C, and D. Okay, now in the claims, I claim only A and B. I do not put C and D in the claims. So I will have legal protection of monopoly right only for the two features A and B. I will not have it for C and D. So claims are the heart of the patent application, and it is very important that the claims have to be drafted very carefully and judiciously. So moving on, who can apply for a patent? So any individual or any company can apply for a patent application. So moving on, we will look at some basic types of patent application. Now we have three types of patent applications here: the provisional patent, non-provisional or the complete specification, and international patent application. So there are some other more subtypes of patent applications, but since we are looking at the basics, we'll go through these three types that are listed here. So first one is the provisional patent. So what is a provisional patent? A provisional patent is basically you have a concept of an idea, you do not have a full-fledged working solution, but you want to protect your IP quickly so that no one else will come up with a similar idea and file a patent for that. So then what you do is you file a provisional patent application. So a provisional patent application does not have all the parts that we have seen in the earlier slide. It need not necessarily have claims. So it is like, okay, I have this idea and I'm working on this idea and I need to secure a particular date and get that priority date for my idea and stop others from filing a patent for similar idea. So you file a provisional patent application. Once you file a provisional patent application, then the patent office will give you a certain time frame within which you need to file the complete specification. So now India has this time frame of 12 months. So let's say I'm working on an idea, the prototype is not yet ready and I'm not sure if my idea will work or not. But meanwhile, I don't want that I keep working on the idea for 1 year and at the end of 1 year, I find out that, 6 months before someone filed a similar patent for a similar idea. What do I do now? So for such kind of situation, you file a provisional patent as soon as you have a concrete conceptualization of your idea. Then you take those 12 months of time frame to work on your prototype, see if it is giving you the required results, see if that prototype is working successfully. And then within 12 months, by the end of the 12 month, you are supposed to file the complete specification patent application. Now this is a full-fledged patent application and it will have everything that we discussed in the earlier slides. It will have the claims section, which will be the most important section. So you are supposed to file this complete specification. If you do not file this complete specification within those 12 months, then your provisional patent application will be abandoned and you will not have any IP rights. So this provisional patent application is not even published by the patent office. It is only like, you kind of block your right on that particular idea, saying this idea is mine and I'm working on it and I need some time to file the full and actual patent application. So for this reason, you file a provisional and then within 12 months, you file the complete specification. Now, let's say I have had an idea, I filed a provisional in India and, by the end of the 12 months, I filed the complete specification application. Now I want to file in some of the foreign countries. So to file in the foreign countries, there are two methods that you can take. One is the PCT route, which is the Patent Cooperation Treaty, which we will see a little bit in detail in one of our further slides. And another is the convention application, where you directly file in foreign countries of your interest. So that we will see more briefly in the further slides. So moving on, now that we have seen, what patent is and what all needs to be covered in the patent. So we look at whether any idea can be patented. Can I patent anything? So like we have seen earlier, the idea will give you the what part of your concept. The invention is the how-to part, or how to make your idea feasible. So idea per se cannot be patented, but the invention or the how-to part or the implementation part of your idea can definitely be patented. So then, are all inventions patentable? Any invention is patentable? Then the answer is no. Every government who is giving you that monopoly right of each country has defined certain parameters, and your idea has to pass through all of those parameters for your invention to classify as a patentable idea or for it to be granted as a patent. So what are those parameters? We will see that in the further slides, and I will hand over to my colleague Pallavi for the further slides. Over to you, Pallavi. Pallavi, you are on mute.
Yeah, thank you, Pranjali, for explaining the importance of IPR and explaining what are the different types of IP rights. Now we will see what is the patentability test is. So if you are thinking of patenting your invention, then your invention needs to pass through a certain, your invention need to pass the patentability test. So basically there are three criterias of the patentability: novelty, inventiveness, and industrial applicability. So what is mean by novelty? So novelty means that your invention should not be disclosed anywhere in any format across the world, not even by yourself. Many a times what happens is that out of enthusiasm, people post their ideas or invention or working model of their prototype on the social media or web, and that's where the novelty of your idea is lost. So until you file your patent application, you should keep your idea strictly confidential. Don't disclose it anywhere in any format. uh, any format. So basically, the prior art search is conducted to determine the novelty of the idea. So what is mean by this prior art search and how it is conducted, where we can conduct it? We will see more about these details in upcoming slides. So next criteria is the non-obviousness or inventive step. So what is mean by inventive step again? So your invention should not be obvious to a person skilled in the art. So it should have some technical advance or economic benefit compared to the existing solution. So let us take an example. So let us take an example of a laser with a pen. So I have a pen and I have a laser. Sorry, there is some problem at my end.
You're audible, Pallavi.
Yeah. Somehow, Pranjali, I'm not able to see my screen. So let me, anyway, let me complete it. So if I have a pen, so let us take an example of a pen with a laser. So I have a pen, I have a laser. So now the thing is that pen is already known in the prior art and laser is also known in the prior art. So if I'm combining just these two things, then it is obvious for a person skilled in the art to combine these two things and come up with pen with a laser. So next criteria is the industrial applicability. So your invention should have some invention should be capable of being used in the industry. It should have some industrial applicability. So along with these three criteria, your invention should fall into the defined classes of patentable subject matter. So according to the country, there might be some deviation in the statutory classes, like software inventions are not patentable in India, but they can be patented in US. Are you able to see the next slide?
No, so do you want to just stop sharing and reshare it?
I think I have to join again.
Please stop sharing, Pallavi. I will check if I can share.
Yeah. Hello.
Yes, just a second. Is my screen visible?
No, Pranjali, not yet.
Still not?
No, I think so. I think Pallavi's screen has got stuck over here, so maybe because can't share the screen. One second. Just check.
Yeah, for some reason, even I'm not able to share. Sorry for this technical issue, viewers. We'll get back soon.
Yeah, Pranjali, can you just now try sharing your screen?
Yes, I think it is. I think I should be able to share it now.
Yes, we can see your screen. One second.
See it?
Yes. Yeah, we can see it. Just go to this. Yeah.
Pallavi, are you able to see? Pallavi?
Left the meeting or she'll join.
Okay, so I think we'll just continue with this. Looks like Pallavi is having some technical issues. So we just looked at the patentability test and the non-obviousness criteria. So your idea has to be non-obvious, that is, it should have an inventive step. Like Pallavi mentioned, there should be some technical advancement or economic benefit for your idea. The last part of this patentability test is the statutory class. I think Pallavi covered that as well. Like software is patentable in not patentable in India, whereas it is patentable in US and Europe. Section 3 of the Indian Patent Act defines certain specific ideas which are not patentable. So as you can see, equations or formulas or abstract ideas, or any ideas that are harmful for public in general, like making of an atom bomb and so on, methods of treating human beings, or just rearrangement or duplication of already known devices or substances, these are not patentable according to the Indian Patent Act section 3. Moving on, now that we have seen that your idea has to be unique for it to be patentable, and we have seen that if your idea is disclosed anywhere in any format across the world, then the novelty of your idea is lost. So how do you find out whether your idea is novel or unique or not? So for that, what we need to do is we need to conduct a prior art search. Now, what is a prior art search? What is a prior art? Basically, any kind of publication that discloses your idea similar to your idea becomes a prior art for your idea. So this could be in any format. It could be like paper, blog, news, PPT, anything, a video or anything. So your idea has to be unique, and there should be no similar publication for your idea anywhere in the world. So now, as an ideator, if you think that your idea is unique or novel, you should conduct a basic prior art search and see whether anywhere else a similar idea has been published or not. So for this, you can use free and paid databases. You can use patent databases or literature databases. So there are a couple of free good patent databases, like you can conduct a search on Google Patent. For literature, you can conduct a search on Google Scholar. Then every patent office of each country has a patent office website, which is free, which is also free and accessible for the public. So you can search for patents there as well. So as an ideator, now that we are addressing specifically the Sparkle students here, it is very important that you conduct this basic search, because that will also tell you what all similar ideas are already available in the public domain. It will give you also good pointers on where your idea stands in terms of the novelty and the uniqueness of the idea. So moving on to the next slide. Wow. Yes, we will look at some of the features of a patent application. Now, the term of the patent application. So once you file a patent application, your patent is valid for 20 years from the date of filing the application. This means for 20 years, you will be the exclusive owner of this particular idea for any kind of commercialization, and others would be prevented from using your idea. So it is like a trade-off that you do with the government of the particular country where you are filing a patent application, meaning you say that you give me 20 years of monopoly right, and after that your idea will fall into the public domain. Once a patent is granted, then it is subject to renewal fees so that your patent is in force and remains valid. So every year you are supposed to pay certain renewal fees to continue your patent application. Again, it is the responsibility of the patentee to maintain the patent application and ensure that your patent application is in force and valid and active by paying the required fees every year. And like I mentioned earlier, after 20 years, your patent application will fall into the public domain. So moving on, now let's say you file a patent application in India or your country. Now, if you want to file your patent application in the foreign country, you can either do it through the PCT filing or you can do it through the convention filing. So in PCT filing, what happens is you file, let's say you filed in India. Now within 12 months, you are supposed to file a PCT application. So PCT is just an international patent application that you would file. Now, does it mean that since I have filed an international patent application, I will have an international patent right across all the countries? Then no. After filing a PCT application, you are supposed to file a patent application in each country that is of your interest or where your market is there for your particular idea. Okay. So you file the PCT application and then you have 30 months of time frame to file in the countries of your interest. So this is one route that you can choose, or the other route is direct filing, convention filing, where let's say I file in India and then within 12 months I file in let's say 2 other countries where I know that I have a market for my particular product. So then what is the benefit of going through the PCT filing versus the convention filing? As you can see, let's say I filed in India and then I go through the PCT route and then I file in US and Europe, versus when I go through the convention filing, I file in India and then within 12 months I have to file in US and Europe. Whereas in PCT, I will get those additional 30 months of time frame to decide which geographies are important for me, or to do my market study and find out that which countries are really important for me. So this PCT filing route will give you the deferred time and the deferred cost with this additional 30 months. So this is one very good advantage of going through the PCT route. See, many times it will happen that immediately within 12 months you might not be able to assess the markets and determine which countries I want to file in. So patent filing is a very costly affair. So you want to judiciously decide which countries are important for your idea and then file according to that. So this PCT filing will give you 30 months additional time frame to decide that, and also to arrange your finances, because each country is going to you have to pay fees in each country, so it is going to be a costly affair. So these are the two ways in which you can file a foreign patent application. So moving on, we will look at the basic patent process that is followed generally. So as we have seen earlier, let's say you're working on an idea and your prototype is not yet ready. Like we saw that you're not sure if the prototype will work or not. Then what you do is you file a provisional application. Then you work on your idea, take those 12 months, work on your idea and see if it is feasible and if it is successful. If it is not successful, then you are saving money, time and efforts in the patenting process, and you can just drop the idea and your provisional application will go abandoned. But if your prototype is successful and your idea is really working and giving the required results, then you go ahead and you file a complete specification within 12 months of time frame. So then you file a complete specification, and then the patent office will publish your patent application within a certain time frame. So normally it will publish your patent application in the public domain. So your patent application will be available in the public domain within 18 months. If you want, there is also a way in which you can file a request for early publication, and then your application will be published within 1 to 2 months. So let's say now my prototype is successful and I have filed the complete specification. The further process, what happens is that you need to file a request for examination. So now this is not, let's say that I filed a patent application. You might think that, okay, now the patent office has to examine it. It is not an automatic process. You are supposed to file a request for examination. So until you do not file this request for examination, patent office is not going to examine your application. For this also, again, the patent office will give you a time frame of 48 months. Okay, so 4 years from the date of filing, you have this time frame to file this request for examination. But the thing is, like, the more you delay in filing this request for examination, the more delayed your entire patent process would get. So it is advisable that if your idea is good and you want to commercialize it quickly, it is good that you file the examination quickly. So once you file the examination, then the patent office is going to examine your patent application. What does it mean when it will examine your patent application? Like, we conducted a prior art search to assess the novelty of our idea. The patent office will also conduct their own search, and it will assess your idea and evaluate your idea in terms of the 4 parameters that we had seen in our earlier slide, the test, the patentability test that we had seen. So the patent office will conduct that search, and then it will give its opinion saying that whether your idea is unique or not, novel or not, whether it has an inventive step or not. So, and in this, for this evaluation, it will issue the examination report to the applicant or the inventor. So once you have this examination report, then as an inventor or an applicant, you are supposed to respond to this particular examination report that the patent office has given. So you have to respond in terms of the patent office would say why your idea is not novel or why it is not inventive, and it might cite some prior arts, like the prior art search that we saw earlier. Similarly, patent office will will identify some prior arts, some earlier publications that are similar to your idea, and they'll say, look, see, this document is similar, is describing a similar idea to your idea, and that is why your idea is not maybe novel, or does not have an inventive step. So what you need to do is you need to file a response to this and give your technical arguments or rebuttals, citing the differences. Okay, so this idea talks about this particular method, our idea talks about this particular method. So this kind of multiple iterations will happen between you and the patent office, where the patent office will cite certain prior arts. Then based on that, you might have to amend some claims in your patent application. So this happens back and forth a couple of times. So multiple examination reports might be issued by the patent office. The patent office might also schedule a hearing for your application, where face to face you will discuss with the examiner, like, what are the differentiating features of your idea in comparison to the prior art, and then finally the patent will be granted or rejected by the patent office. So moving on, we will look at how, where, and who can file a patent application. So now there are the patent application can be filed either by physical filing, where visit the patent office and with the required fees and the forms in person, and then you go there and file the patent application. Or you could do the filing online through the electronic means at the patent office. So you need to upload all the forms and pay the fees, and then a receipt will be generated with the patent application number. Or you could also send your documents and fees by post to the patent office and file your patent application. But obviously nowadays online is the most preferred form for filing the patent applications. So there are patent offices located in India at these 4 locations, and you can file a patent application accordingly in these locations where your jurisdiction is applicable. And who can file a patent application? Basically, as an inventor or an applicant, you can file your own patent application, or you can get your patent application drafted and filed through a patent agent or a patent attorney. The preferred option always, since we have seen that, patents are complicated techno-legal documents, and you need to have that knowledge and understanding of how to draft the claims and all the other requirements of the patent law. It is always advisable that you get your patent drafted and filed and examined and prosecuted through a patent agent or a patent attorney. So moving on, we will just quickly look at some of the official fees for filing patent applications in India. So I'm sorry. Yeah, so we look at these fees. As you can see, we have listed some of the basic fees that are required for you to file a patent application in India. Patent office has these two buckets for the fees. One is for the natural person, startup, small entity, educational institutions, and other categories for the large entities. You can see that the large entity fees is almost like 5 times that of the other category. So since you being Sparkle students, the fees is very minimal. The government has reduced the fees now for educational institutes also, in order to promote IP and make sure that maximum patents are filed for all the innovative ideas that are coming, that are being developed in India. So the first fee is obviously for filing a provisional or a complete specification. Like we had seen earlier, you could request for an early publication. This is optional and it is not mandatory. But if you want that your application should get published quickly, then you can file this request. And like we had seen earlier, we also need to file a request for examination, because unless you file that, your patent application will not be examined. So you file this request for examination, and then like we have seen earlier, to keep your patent application going, you need to pay renewal fees or annuity fees every year, and from the second year up to the last 20th year. So this is just to give an overview of the fees, official fees. Moving on, now that we have looked at all the basic processes related to how to protect your own IP, like we mentioned earlier, there's another aspect of IP which is called as the IP or patent infringement. So like you are going to protect your own IP, excuse me, others are also going to protect their own IP and their own ideas. So you need to make sure that you are also taking care of not to have any improper use of other people's IP. So what is patent or IP infringement? Any kind of unauthorized use of any form of intellectual property without the permission of the owner or the creator is basically constitutes an IP infringement or a patent infringement. Now, any kind of IP infringement is pretty costly, is time consuming. It could cause some damage, to the business. It could cause some damage to your direct and indirect customers. It could cause damage to the third party people who are involved in your idea. And that is why you have to be very careful that you are not infringing or knowingly or unknowingly kind of using anybody else's IP or anyone else's creations. Okay. So normally people will think, that I have conducted a search and I did not find any such patent, similar patent, and I can use this particular idea, or I don't think anybody will sue us, and I know everything about the market. We can just use this, or we can just copy this. Even from the internet nowadays, people just copy. Let's say, to give very basic example, you just copy images, you copy code. So ideally you are not supposed to copy such contents. You are supposed to respect other people's IP rights, and you need to make sure that you are not infringing anyone else's IP. And at the same time, since you have protected your own IP, it is also important that you also keep a watch on if anybody is infringing your IP rights or using your IP without your permission, knowingly or unknowingly. So moving on, since we are addressing the Sparkle students here and we are talking about students in colleges, we will look at some IP issues specifically for these kinds of environments where, in the for the IP rights, let's say there is an idea and then multiple parties are involved in this idea. So there will be students, there will be professors, colleges, universities, and if you're working with some industry or with some company, then that company also might be associated in the project that you are working on. So when multiple such entities are involved in the creation of a particular product, then it is very important that you have all the IP issues addressed right at the beginning. So this is more from the college or institution perspective, that it is very important, that you define all the ownerships, all the IP rights, all the IP processes, compliance, the revenues and the royalty sharings, and all these issues have to be addressed properly before you file a IP, so that there is clarity and there is a proper streamlining of the IP rights ownership and all the issues that come along with these IP rights. So it is better to have the IP policies in place. If you can have an IP team, or if you can have this IP awareness and make sure that there are provisions for each of these issues and they are addressed properly, then you will have a smooth IP process right from the filing up to the commercialization. So moving on, we will just summarize quickly all the highlights of whatever we have covered in this session. So first and foremost, it is very important that you keep your idea or invention a secret. As we have seen, the novelty of your idea is very, very important. If you disclose your idea anywhere out publicly, then you are destroying the novelty of your idea. So before you disclose your idea, assess whether your idea is unique or novel and whether you need to file a patent or any form of IP for that idea, and then only disclose it in the public domain in any form. If you have multiple parties that are involved in your idea, let's say in developing the prototype, there are too many other third-party vendors or companies or any industrial people that are involved, or anyone else that is involved, make sure that you have proper non-disclosure agreements in place, so that every party who is involved in the idea will have that obligation of not to disclose the idea anywhere outside in the public. You also conduct a basic prior art search for your idea. It will be good for you to understand where your idea stands, how novel or how unique it is, and you will also see what others are doing to address the similar problem. Make regular notes of the progress of your idea, so that you can track the progress of your idea, and also you will have a gauge of the patent office deadlines, when you need to file what, and accordingly you will be able to ensure that your idea progresses according to those timelines. So do not ignore the patent office deadlines, follow those, because some of the deadlines that the patent office has are non-negotiable and non-extensible. So once you miss those deadlines, you will not be able to do anything about it. And have the basic IP awareness, know the basic patenting processes and terms, and make sure that you identify your unique and novel ideas, identify your good ideas, protect your own ideas, and at the same time make sure that you respect other people's ideas. Moving on, we'll just quickly address some of the FAQs which we have been conducting so many sessions, and based on that we have come up with some questions that are frequently asked. Okay, so the first question that we will address is, let's say you have a unique idea but you did not know at the time about patent and IP rights and so on, and it was a really unique idea, and now someone else has filed a patent application for the same idea. So what can I do about it? I cannot emphasize this or reiterate this more than enough, that you have to ensure that you maintain the novelty of your idea. It is very, very important that you first file a patent application, at least a provisional, before you disclose your idea in public, because if such things happen, then there is not really much that you can do, and there are other ways you can defend your idea, but ideally it is expected that you file a patent application before you disclose the idea anywhere in the public. The other question is like, I have an idea and there is a similar patent. There is a patent in US for a similar idea, very, very similar idea. And can I file a patent for my idea in India? So like we have seen just now, patents are, even though patents are territorial rights, prior art that establishes the novelty of your idea can be published anywhere in any part of the world. Okay, so if there is a similar patent, let's say in US or Europe or any other country in the world, your idea, the novelty of your idea is lost. So if there is a similar patent or publication or any other literature or any disclosure of a similar idea, then it is not the chances of your idea being novel and getting a patent are very, very less, because that particular publication will constitute as a prior art for your idea. The next question is, I have filed a patent in India. Can anyone copy my idea in US or Europe? Now, again, to address this, as we have seen earlier, patents are territorial rights. In terms of enforcement, in terms of prior art, the prior art can be global, but the patent enforcement has to be territorial. They are just territorial rights. So if I file a patent in India, I get monopoly exclusive right to prevent anyone else from copying my idea only in India. So people can use your idea in US and Europe if you do not have a patent in US and Europe. So you need to be very careful about filing patents in all the countries, in all the geographies where you are going to market your solution or your product. And the last question that we will address is more specifically for the students and Sparkle students. Let's say you have a unique idea, then do I need to take permission from my college or professor to file a patent application? So these are the IP issues that we were discussing in the earlier slides. So your college will have certain IP policies in place, and if you have developed that idea, during the course of your college hours, using the college resources and so on, and you have well-defined IP policies in your college, then it is definitely advisable to get the permission from the college or the professor. And for the college also, it is beneficial to have such policies, good policies in place, so that students are aware of what they need to do and what they need not should not do in terms of the novel ideas that they have come up with, and in terms of how to protect those ideas. So these are some of the FAQs that we have addressed, and now I think we should take a few live questions maybe. If the team can pass on some questions, we will address those. Sahil or anyone?
Yes, Pranjali. So we're waiting for questions from students. We'll just wait for this like 30 seconds. We'll see if there are any questions. I'll just pass it on.
Sure.
So Pranjali, we do have few questions, and so there's Saurabh Bhole who He wants to know, ma'am, is there any free agency which can help us to patent our idea?
Yes, good question. And I do understand that as students, you will have some financial limitations and you would look for, patenting in at some economical or reasonable costs. I said that you should go through patent agents and law firms. So there are law firms will have a variable, schedule of charges. Each law firm will have their own schedule of charges. So there are some law firms who will charge reasonably. There are some law firms which will have expensive charges and so on. But the patent office, especially for the students and colleges, there is something called as IP facilitators. So there is a list of IP facilitators that is available on the Patent India Patent Office website. So for them, they will help you to file your patent application at a much reasonable rate, at a subsidized rate, because the government would be bearing some part of that cost for you. So you can check out the list of the IP facilitators and connect with some of them and see if they will handle the idea for you.
Great. I think, Saurabh, I think that answers your question. So moving on, we have another question from Dheeraj Pawar. So he's asking, what about software projects? Should we go for trademark?
Software projects, is it?
Yes.
Yeah, so for software projects, Dheeraj, like we have seen, software per se is not really patentable in India, and you could explore options of either trademark or copyright for your software ideas. Again, also the enforcement of even though if you file a patent application for your software, if you combine it with some particular hardware, and even if you do file it, the enforcement of pure software patents is again a question. So again, this is a subject to case basis evaluation. Okay, unless I know what the idea is exactly and all the other details, it is really difficult to give you an opinion. But just to give you some pointers, like I said, enforcement of pure software patents per se is also a tricky thing. Pure software patent is anyways not patentable in India, so you could explore other forms of IP like trademarks or copyrights, more importantly copyrights. But then again, this has to be evaluated once we know the details of the idea.
Okay, great.
We can take one or two questions more maybe, and then we will conclude the session.
So there's one more question from Dheeraj. So he's asking, how can we file a pure software patent in India?
How can we file
A pure software patent in India?
Yeah, so like I said, Dheeraj, pure software patents per se are not patentable in India. It is really difficult. You can file a patent application. It will go for the examination, and then the patent office will come up with the Section 3K objections saying, that this is just a software and it is automating certain processes, and they have their standard rejections arguments for such kinds of patents. But you can always try and club it with some hardware, probably bring in some hardware aspect to that idea, and then maybe you can try for a patent. Again, I need to look at the details of the ideas before I can give you any concrete answers or inputs to this.
Okay, so there's one more question. So does IP protection have a time limit?
Yes, like we have seen, different forms of IP will have different terms, different tenure of protection. So patents will have 20 years, design trademarks will have 10 years, and so on. So each of these IP has a specific time frame.
Okay, okay.
Yes, I think
So
we are Yes. Do we have any other questions, or I think we are about the end time?
So there's a question from Aniket. So he's saying, I'm working in a team. Can you guide us on how to assign IP amongst us?
Okay. When you say how to assign IP amongst us, I'm not really clear on the question. Maybe what you want to say is how do you assign the IP rights or the ownership is what you are asking. If that is the case, you should know that as per the patent laws, all the inventors, all the applicants that are listed on a patent application, uh, if it is an applicant, then the applicant would own the IP rights. But all the entities that are listed on the patent application as the ideators or applicants will have equal rights of ownership and commercialization of that particular IP. So let's say we are four of us in the project team, and we have this idea, and we have filed a patent, and four of us are the inventors. Then all four of them will be having equal IP rights for any kind of commercialization of that IP. And also they will have equal liabilities as well at the same time. So I hope this is what you meant by how do you assign IP. I'm not really clear on that.
Okay. So we'll take one last question. So Saurabh was asking, ma'am, is there any software to check our project availability involved?
Software to check project availability?
Involved. So
Yeah, so no, the answer, I mean, so you want to check whether your project is novel or whatever you are doing is novel or unique or not. So again, there is no one unique software as such which will, kind of give you a search across the globe. But like I said, there are some paid databases, patent databases as well as literature databases, which will give you access to most of the patent offices and most of the literature across the globe. But then again, see, locating a prior art or doing a novelty search is like looking for a needle in a haystack. Okay, so we are talking about prior art that could be published in any corner of the world, anywhere. You really need to do a very, very thorough and exhaustive search to find out whether your idea is unique or not, and that actually takes time, effort, and skill set to be able to do so. It's not, there is not really one such one single click solution where I just put in and click and then it will tell me whether such similar idea is there already anywhere or not. So you have to search very, very thoroughly and exhaustively using multiple databases, and multiple literature and patent databases. So it's an exhaustive process, but you can definitely get some idea with some basic level of quick search, like I mentioned earlier. I hope that answers your question. So are we
okay,
done?
then yeah, I think that was the last question we can take for today. Yes. So yeah. So thank you, Pranjali, and thank you, Pallavi, for such an enlightening and entertaining session on IP.
Thank you,
Um,
Sahil.
yeah, if
Yeah,
we
thank
have
you, Sai.
yes, if we have missed your questions, please mail them to us to KPIT Sparkle 2023 @kpit.com. We I think we'll stop for today. Thank you for joining, everyone, and bye. Have a pleasant evening.
Thank you for joining and watching the video. Thank you.
Rosalind, we'll stop recording.